Hi, I'm Charina Garcia. I'm the Strategy and Innovation Partner here at WR Immigration, and we are having our Chatting with Charlie to talk about the January 2024 Visa Bulletin update. We are also celebrating the 1-year anniversary of Chatting with Charlie, and so Charlie will give you some Visa Bulletin highlights as well. So Charlie leads our government relations group. He was the chief of the State Department's Visa Control Unit for 23 years, where he directed all the numerically controlled immigrant visas. Laura, again, is joining us. Thank you, Laura. And she's going to give us some, great feedback, what's on the top of mind of our global mobility managers. And with that, we'll move to the next slide. Again, a legal disclaimer, this does not constitute legal advice, informational purposes only. If you have any questions or would like to schedule a consultation, please contact our office and the information is there. Laura and Charlie, you want to introduce yourselves?
Sure, I'll kick us off. I'm Laura Bloniarz. Like Charina said, I support our business immigration practice. So my clients are companies who hire and sponsor foreign national employees. I represent all sorts of industries, most recently focusing on biotech, finance, and tech.
Hello, and I'm Charlie Oppenheim, Director of Visa Consulting. I do this webinar. We also do one with Joey Barnett on the Employment Fifth Preference Investor Visa program on a monthly basis. Do other consulting in terms of proposed immigration bills that pop up from time to time, and a variety of other consultations.
Great. So with that, just a little bit about WR Immigration. Our mission is Journey Forward. We have 9 offices globally with over 150 professionals, and we provide innovative technology solutions with our rapid technology that's built on Salesforce. Next slide. So this is our roadmap, and we're going to talk about the Visa Bulletin highlights just to end off the year, do a summary of the January Visa Bulletin and the Bulletin trends, and then we're going to do our February predictions for employment-based and family-based final action. And then we'll roll into question and answers. And of course, you can put your Q&A here in the box, and if we have time, we'll go ahead and answer it. If not, we'll answer it in the next session in January. So, Charlie, let's talk about some Visa Bulletin highlights over the past year.
Yeah, I think that, the key one is that virtually all of the numbers that were available in the employment categories during fiscal 2023 were used. That's amazing news for anybody that's in the waiting line, because we were able to clear through a lot of people that are waiting for an extended period of time. The guidance we provide in these events have proven accurate over time. We always try to provide and make realistic estimates to prevent anybody from having unfounded assumptions or getting your hopes up. When I was chief of immigrant visa control and asked about things, I never wanted to get people's hopes up with undue and unrealistic expectations. And I still do that. I would prefer my predictions to underestimate potential movements, feeling that people are always happy if a final action date or an application date is to move more than predicted, versus if it were predicted to move, a month and it only moved 1 week, they could be upset. And during the coming year, we'll continue to provide projections that will help people with their planning. One thing I forgot to mention is that I'm being interviewed. I've had 2 articles in Forbes magazine, and I think there's one coming up in the Washington Post where the immigration community's asking for advice and updates.
Great. Laura, any Visa Bulletin highlights for you from the corporate side, from the global mobility angle?
Well, Charlie's really our celebrity here, and he's the one that provides all the information that we need. And when I'm talking with clients, prospective clients, employees. I'm driving them to like and subscribe our webinar here because this is really helpful to contextualize like what is the Visa Bulletin. If you're new to the global mobility profession, it can be really hard to understand why this Visa Bulletin exists, what its purpose is. And if you're managing a large foreign national population in the US, you want to understand the trends because your employees will have these types of questions with how is the company supporting me, projecting fees. And so this is a nice webinar to contextualize all that. So more to come in the new year. And again, if you have any specific questions on how to manage your program, reach out to Charina and I.
Yeah, thank you. All right. Well, now we'll start looking at the January Visa Bulletin. So this first slide is the employment-based dates for filing. And Charlie, we're seeing some big movement here for dates for filing for China and India. So can you talk a little bit about that?
Yes. The movements, it's very nice, and we had expected movements earlier. Hopefully this will be continuing. But again, these dates for filing are where the dates are projected to be at the end of the fiscal year. So hopefully these dates will be reached by September.
Okay. And then about that typo, I know there was a little bit of confusion about that typo. Can you tell people a little bit about the typo that occurred for EB?
Yeah. The typo in the second preference, I believe they had listed it initially as January of 2020 for China employment second. And the date, it has been corrected in the Visa Bulletin. The correct date is June 1st of 2020. I think that initial typo caused a little heartburn for some people.
Yeah, we read about it in many, many posts. So we can move to the next slide. And so let's talk about our trends and our employment-based final action trends. And the orange depicts movement in the Visa Bulletin, and of course, the black arrows depict retrogression. So we see here EB1C remained current. EB2, rest of world, moved up to November 1, 2022. And then EB3, rest of world, also moved up to August 1, 2021. Any feedback on this movement, Charlie, or any observations?
Well, in terms of the movement, we did see a lot of movement in the January dates across the board. And in the past, in these events, I've mentioned the State Department will establish preference category and certain country per country limits, and they set targets on how many numbers they would like to use in a given month. And that way they move the dates based on their targets to either increase number use or hold number use as the year goes on. And it's important to remember that the October dates are established in early September, the November dates in early October, December and early November. So it isn't until the January dates are established that the State Department really has enough information to determine if their estimates of number use in the earlier months have been correct, or if they need to make slight adjustments. And I think that may have been what happened for January, is they saw that number use was less than they anticipated during the earlier months, and that they kind of cast the net wider, so more people are eligible for adjustment of status or to be interviewed at overseas posts, so that they can, by the end of January, they can have their targeted number use at a level where they want to have it done. The other option, go ahead. Well, there is another option that is possible. It's much less likely. Again, I think that it was corrective action on the January. The other issue is that the first quarter of the fiscal year is for October through December. And many of those watching the webinars, and is illustrated on this chart, in many of the categories, there was only one movement of a date during November and 2 dates advanced for November. So it is possible that the State Department decided we're going to establish dates in October that we think we can hold, possibly make minor adjustments if our estimates are low, but set the October dates for the entire first quarter. And then they would do the same thing in January. And they may want to do this, as I said, so they could have more time to determine the impact that the earlier movement of the dates is having. And so therefore, and this will only be proven out once we see the February dates. If they're like that was done for November and December, are the February dates being held or are they being advanced? But again, either way, the State Department now has more information to make accurate decisions. And I know that the State Department and USCIS want to avoid volatility in the final action dates, because as much problems as it creates for the applicants and the HR departments, everybody else, it creates problems for the government that they want to avoid, because they have to answer lots of questions and take time doing that. So they're feeling your pain, maybe not to the extent, but they want to, minimize volatility in the dates in the coming year, because there had been so much volatility the past 2 fiscal years.
Yeah, I mean, last month, chatting with Charlie, there really wasn't much to talk about because the dates hadn't moved in December. So it's nice to see that there is some movement in January. We can go to the next slide. So this is for China. So again, we saw some movement as well. So do you want to talk a little bit about the January China movement?
Yeah, this is where I said, all the China dates moved, which is great. And they moved by a big amount. But you will see that in November and December, there was minimal. That's where in China for December, they had the 2 movements. And that's where I started coming up with this idea, if they made the quarterly date establishment.
Okay.
But this is, this is good, but I caution anybody to look at the movement of dates between December and January. Do not assume that this is going to be the type of movements that will be going forward. That would be very risky at this point. It may prove to be correct, but I think it is far too early to make such assumptions at this point.
Yeah, usually I see when you're predicting, you're only predicting maybe 1 to 2 weeks, but we're seeing some significant movement. And significant in our world is when it moves by a month, right?
Right. And again, these type of significant movements would support my idea that maybe they're going to a quarterly, for the first half of the year, they're going to quarterly establishment of dates.
And we have a question from the queue here that's relevant. Charlie, do you think this is Charlie's theory about the quarterly movement. Do you think they will continue to limit movement on a quarterly basis?
The reason I came up with this is because of the November, December dates really not moving. And I thought that, okay, in the past 2 fiscal years, there's been a lot of volatility. The dates were moving forward at very rapid rates only to retrogress, or sometimes they would retrogress 1 month and retrogress again the next month. And the reason for such volatility is sometimes the lack of being able to accurately predict demand and number usage. So if they went to this quarterly, they would have some time to make sure that their estimates are correct, that they didn't overestimate, and if they have underestimated, say if their quarterly limit for October through December for the worldwide first preference was to use 12,000 numbers. If they only had used 10,000, well, then for January in the next quarter, they can up that so that they get their number use up. But if they were, over, then they would just be able to hold. So again, they have, during this first part of the year, they have time to kind of sit back and look at things. Also, there is so much demand in the employment first preference for both China and India, and demand in the other preference categories, they have the luxury of being able to hold those dates till later in the year, knowing that if they have to advance the dates, they already have a pool of demand there. And with the Immigration Service doing the vast majority of the numbers in employment, those numbers can get processed very quickly. I used to work very closely with the service center operations, and they would often ask me for projections where I thought the date was going to be, 4 or 5 months down the road. And then they could, if they saw that they needed RFEs on it to get additional information, they could go ahead and generate those letters, get it. So when the demand, when the dates did move, they were ready to go. So it was kind of a luxury knowing you had it out there.
And the goal really with Department of State is to hold or move forward, right? It's not to retrogress.
Yes, the main goal is to have things go in a steady and orderly projection so that there is not this volatility. And again, like I said, I would often know that I had plenty of India second preference numbers available, but I was not confident in, what the potential demand that was still out there with numbers. And so I knew that I had this pool of people that if I had to wait and start moving the India second preference date rapidly in the summer months, I could still use all the numbers, even though I may have held off until that time to make sure that I knew I had this pool of numbers that were going to still be available, and I hadn't used them early, only to find myself having to retrogress the date later in the fiscal year.
Okay, let's move on to the next slide. And this again is India, right? So
Yep.
we see a pretty big jump, right, for EB1. And then a little bit of a movement in EB2, and then a little bit of movement in EB3. So any comments on the big jump in EB1 India?
The India EB1, it's an unrealistic jump that people shouldn't get super excited with, because the January 2017 date was basically a line in the sand that to minimize India India employment first preference number use again until they saw what type of demand. Now that the date has moved to September 1st of 2020, that's really just basically recovering from the end of year retrogression, which occurred last year. And people have to remember, at one time, both India and China first preference was current. So this while it's very good, it shouldn't be expected. People shouldn't be expecting, it moved 3 years almost, it's going to move another 3 years for February. Do not expect that.
Well, if you just do a look back, look at January 2023 Visa Bulletin, they're at February 1, 2022.
Right. So this is just recovering ground.
Yeah.
And again, they want to see how much, is there a lot of demand still out there with people that have priority dates earlier than September 2020. And that's one of the things. Sometimes people see these dates and assume that everybody in the world with a priority date earlier than that date has been taken care of. And it's important to remember that applicants can process at their own convenience and pace. But again, also sometimes that people are upgrading from a lower category and may have an earlier priority date. They may be upgrading from India's second preference and may have a 2018 date or 19 date. So they are having to see, okay, how much of this new demand are we getting? Or were there any other type of petition processing backlogs? So, they're clearing out those backlogs, and dates, demand with earlier dates is still being received.
And Laura, aren't we seeing that? Aren't we seeing more and more people asking us about how can I qualify under EB1?
Yeah, I mean, absolutely. I have a case where the gentleman has a very early priority date, meaning probably a 2015 priority date, and he's currently on an assignment abroad as a manager, and then will re-enter the U.S. The plan is in, now 10 months for his EB1 strategy. So he's going to be one of these people that has a 2015 priority date in EB1. And USCIS is, going to be like, where have you been? But it's really a strategy because that's a faster route. And the business and his family was able to accommodate this international assignment. So while it's unusual, it's becoming more common given some strategy for EB1.
Yeah, we're seeing that too as well. We can go to the next slide. So, all right, Charlie, what are your predictions for future movement?
Yeah, I'm pretty much holding with my previous predictions. I think over the course of the fiscal year, we've had it, like I said, we had big jumps for the month of January, but I think over the course of time, the movements will average out to approximate these movements. And again, if you go with this type of movement, you're going to be pleasantly surprised if the India EB1 movement, it jumped 3 years, like I said, kind of artificial for the month of January. But, if I had been saying 4 years, you'd be upset. Saying 1 to 2 months, you're extremely happy. So again, these could be considered maybe worst case scenarios for the movement and be pleasantly surprised if they go faster.
Well, I mean, and our caveat here, right, is his predictions are over the course of the entire fiscal year, right? So yeah. Even if October 2023, it was, I think India was at 2017 or something like that. And then at the end of September 2024, if they retrogress or they push it back, so those always can happen as well. So just want everyone to know this isn't what he's predicting for February. This is his prediction for the fiscal year.
And that we did have a related question from someone on the chat. How are they able to move the filing chart dates? So just to summarize, Charlie's predictions here relate to the final action dates. But Charlie, could you comment on how Department of State moves the filing chart dates?
Yeah, the application filing dates are where the State Department, in conjunction with consultations with USCIS, believes the final action date will be in September. So they will, if they thought that their originally announced application filing dates will not allow enough people to have filed and be in the pipeline for processing, then they will move the dates forward to allow for that. For example, in the India, they changed the date. It had been July 1st of 2019. They have now moved it to January 1st of 2021 for the India Employment First. So they had advanced. They said, we're not going to have enough people if we hold that July 1st of 2019 date. This is, and it's one thing that anybody that is thinking of adjustment of status filing, to do so in a very timely manner. If you're eligible to file based on the application filing dates that have been announced for January, I would strongly suggest that you act quickly, because there is no guarantee on how long the Immigration Service may allow those application filing dates to be used. Typically, they allow them to be used anywhere from January to March before they finally stop allowing them to be used, at which time you have to rely on the Chart A. So if you have the chance, take advantage of it. Don't drag your feet.
Yep. All right, next slide. So Laura, can you talk a little bit about this and the data that USCIS recently provided?
Yeah, so last week, USCIS provided some really helpful, insightful FAQs. So if you haven't seen that update, you can check it out on the USCIS website. Essentially, they're confirming that Department of State is estimating the fiscal year 2024 employment-based annual limit will be approximately 161,000 visas. That they also stated that they used all of the employment-based immigrant visas from last year, apart from the reserved EB-5. So that's the positive news that Charlie was sharing, and that from this data, you can see that USCIS is adjudicating about 75% of the annual limit for employment-based visas. So when Charlie's making his prediction, something to think about is that Department of State data is what he's looking at, is what he's familiar with. But that is only a small slice of the actual usage of the employment-based visas, because USCIS accounts for such a large portion of all the adjudications, which in Charina and our practice, we can say that, the majority of our clients, the employees, are filing adjustment of status from inside the U.S. There's very rare instances where the sponsored foreign national employee is adjusting status from outside the U.S. So it makes sense that USCIS is accountable for the majority of the employment-based immigrant visas.
Yeah, and just to go back to Charlie's point, right? Because if they're using targets, but then all of a sudden, Charlie, there's this big surge of, immigrant visa numbers requested by USCIS, then your targets have to be adjusted, right?
Right. And I can tell you a kind of a story from probably four years or so ago. There was the application filing dates, it was for India third preference. The application filing date was established, announced for October. It was based on the best information available at the time. And within a month or so, the service saw that the amount of India third preference applicants who were filing based on the application filing date was tens of thousands higher than they had estimated. I mean, not just 10 or 20, but 40, 50,000 more than had been anticipated. Again, the information that available at the time made it reasonable, but after they saw what was coming in, and then it was necessary to retrogress that application filing date. So again, you have to deal and make the decisions. The government is making the decisions on the information available at the time they're making them, and things can change in the upcoming month or months.
Yep, that's true. All right, we can go to the next slide. And then now we're going to talk about the family-sponsored dates for filing, because we get a lot of questions about the family. So Charlie, can you comment on this?
Yeah, I think that the movement of the filing dates, they were so far out that I think that the State Department, the vast majority, probably 95% of the family numbers are used overseas. And so the State Department has an excellent view of the demand that is there. And so I don't feel that they think that they need to be advancing the application filing dates at this time. That does not mean that they won't begin to use them in the coming months. So it's just kind of a wait and see issue on family.
Okay. And then the next slide, these are the final action dates. So any comments on this?
I think this is a very positive thing. It shows that they have, they've processed a lot of the backlog that had accumulated during the COVID times, when most of the overseas posts were closed for an extended period of time. And then when they started reopening, they were having to recover from all the work that had not been processed during that time. So I think they're kind of getting out of that backlog effort now, and hopefully we'll start to see more steady or more consistent movement of the family sponsored final action dates.
Okay. And then your predictions, Charlie, for family sponsored?
Yeah, and again, like I said, I think it'll be slow, but hopefully steady as they come out of the recovery stage and more of the overseas posts are back to, quote, normal processing levels.
Okay. And then we're going to talk about, we get a lot of questions about EB3 rest of the world. Other workers, rest of the world, other workers. And so Charlie, can you comment on this?
Yeah, I think that at this point, it's too early to speculate on whether the rest of world final action date will be able to reach January 2021 by September. We may have a much better indication by the time we hold the March chatting with Charlie. And it's important to remember that the employment third preference other worker category has a limit of up to 10,000 numbers. So up to can range from 1 to the 10,000. And there is huge amount of demand that has been coming forward by new filings in the rest of world category, which could severely limit the forward movement of that date in the future.
And other workers are typically are positions that don't require a degree or don't require years of experience, and that's why it's classified as other workers, correct?
Correct.
Yeah. Okay.
And that's why it's also in the immigration nationality, they set the limit as up to 10,000 numbers.
Okay. And these are where we usually see the caregivers, right, in terms of other workers.
You see a lot of them. A variety of that don't require, say, a bachelor's degree or the higher skill levels.
Okay. All right. Next slide. How are the employment base per country limit calculated?
Okay. So this is a chart. This is much easier than my rambling on how it's set. But what they do is the annual limit is at 161,000, and the Immigration and Nationality Act says they establish a 7% per country limit, and they set that limit to avoid a handful of countries from potentially monopolizing the vast majority or virtually all of the numbers. So if you multiply 7% against 161, you come out with a China, India, Brazil, Great Britain, and per country limit of 11,270. Then each of the employment categories is assigned a percentage limit. The first, second, third get 28.6% of the worldwide or per country limit, and the employment fourth and fifth preference gets 7.1, and that results in these totals. In earlier events, we've showed how these numbers, for example, the fourth and fifth numbers that are unused potentially could fall up to the employment first, and any unused employment first numbers would fall to employment second. Any unused there fall to employment third. If for some reason there were unused third preference numbers, they also fall up to employment first. So it's kind of a cascading and updraft type of effect. But again, this is how the numbers break down. And this illustrates why the India and the China dates are moving very slowly this year, is they are limited in the first, second, third preference category, the 3,224 numbers. That's all they can get, as long as there is a rest of world final action date listed. In the first preference, rest of world is current, so there may be some otherwise unused numbers that can be made available to India. Right now, in second and third preference, there's rest of world final action dates. So there, unlike earlier years, there is no otherwise unused rest of world numbers, which can fall to be used by India and China in their second and third preferences.
So just to boil it down, right? So each country, like let's just use EB3, for example. Each country, India, where you're born, India, China, Philippines, Japan, what have you, is 3,223. And typically India and China will actually utilize all their numbers. So they have to wait and see if Japan or the UK or the Philippines doesn't use up their allocation of 3,223. And if they don't use up their allocation, then that's when it'll move up or down, right?
Right. And when you see the final action date listed, that is to prevent these limits from being exceeded.
And then when there's extra, like if the country doesn't use it, then it goes into that pool of unused numbers, and then that's when it's determined by priority date.
Correct. So, and that's why, as long as the rest of world stays current, at some point, the State Department may say, we think that there's going to be 5,000 unused rest of world numbers in the employment first preference category. They can make those 5,000 numbers available in priority date order. The Indian applicants have the earliest priority dates. So at this point, it looks like in this example, all 5,000 numbers would be given to Indian applicants in the first preference category. And that's what in fiscal 2022, the India second preference had a limit of approximately 5,000. They ended up using over 55,000 numbers because of the availability of otherwise unused numbers, because rest of world was current.
Yeah, after 1 year of doing these chatting with Charlie's, I feel like I understand it now. So thank you.
Same.
We can go to the next slide. How soon will EB1A be current for Chinese nationals in 2024, Charlie?
I don't anticipate that China EB1 will become current during fiscal 2024.
Okay. And then Laura, a question about alternatives for staying legally in the U.S. if laid off on an O1 or H1B visa. And they typically have a grace period of 60 days to find a new position. And then if leave on an approved I-140, how do you change to immigrant visa processing while in the U.S.?
Yeah, so for the first one, you have the 60-day grace period. So the first answer is to find a new employer that can sponsor your, transfer your H-1B or file a new O1 for you. The H-1B has portability, so as long as a new H-1B has been filed within the 60 days, you can start with that new employer. The O1 would need to be approved, but as long as it's filed within that grace period, you can remain in the U.S. So that's obviously the most straightforward answer. Of course, that's a pretty aggressive timeline to go through an interview process, accept an offer, and have a non-immigrant visa petition filed on your behalf. If you're looking to stay in the U.S. lawfully to job search, you could change your status to a B2 visitor. You would need to file that application timely, meaning within your grace period. And you can request initially up to 6 months. And taking interviews, business meetings are all permissible under a visitor visa. This is something that you're going to want to plan very specifically with immigration counsel. So if this is something that you're considering or in that situation, definitely reach out to WR Immigration for a consult so we can advise specifically, because there are other implications on your application and future benefits.
Yeah, we've actually been successful, Laura, in a lot of our H-1B workers who get laid off, where we actually do a national interest waiver self-sponsored petition.
Amazing.
Yeah, just to have them keep their green card active and available. And of course, if they have an older priority date and able to file an adjustment of status, that's great too. But the national interest waiver has actually been a nice immigrant visa category that has been very helpful for many of these folks as well.
Yeah, that's a good point, because that could be self-sponsored. So again, if that's something, if you're in this situation, definitely reach out to counsel, reach out to WR Immigration for a consult to see if we can help you out. If you leave an unapproved I-140, but meaning you're not eligible to file an adjustment of status or have not yet, how can you change to the immigrant visa processing while in the U.S.? Charina, I've never dealt with this situation. Have you?
Yes, many times, and it takes a long time. So basically, when you file your I-140, you have to designate whether you want it approved for consular processing or adjustment of status. And most people will select adjustment of status. And when you select adjustment of status, that means that the file stays here in the U.S. If you select consular processing, then the file actually moves to the National Visa Center, which is part of the Department of State, right? And so when your number gets called or is close to being called, then the Department of State will reach out to you and ask you to pay the visa bills and do all of that. But we've seen many clients, even though it's approved for consular processing, they actually still file an adjustment of status, right? Which I think, Charlie, confuses everyone, because you're thinking that they're going to process abroad and then you don't know that they actually have an adjustment of status filed, and then they get their green card issued, and then Department of State is still asking you, do you want to continue? Are you going to pay your visa bill? But the process of actually getting your file, if it's an adjustment of status, to the Department of State takes a while. You have to file an I-824. And I haven't checked the processing times, but I've seen it could take up to a year for the file, for the I-824 to be approved and transferred to the Department of State National Visa Center. So something to consider if you're worried about whether you're actually going to be in the U.S. when your prior date becomes current, is to designate it for consular processing versus adjustment of status. So talk to your immigration counsel about that and have them strategize that for you.
Yeah, it sounds like the person that's asking this question is probably needing a consult for more specific advice. This is really what Charina and I are talking about are sort of high-level general guidance without understanding the specifics of your case, as we all know. And then as an attorney, have to say that it's really a case-by-case. So there's going to be certain strategies that are going to make sense for you that aren't going to make sense for someone else.
Yeah. And then I guess this was for Charlie. In your opinion, does the abrupt rise in the prior date actually is reflective of reality? Or would it simply be a miscalculation that might reverse in due course because indeed there was not such a large spillover?
Yeah, I think it is too early to read much into the movement of the January dates, as they mentioned. The January movements could reflect an attempt to kind of align actual number use with the targeted amounts, whether those targeted amounts were based on, excuse me, monthly or quarterly targets. Again, so I think, again, we might have a better indication of this when we see the February dates come out.
Okay, and then next slide. Is F2B rest of world now proceeding 1 month at a time? Will EB2 rest of world be current in fiscal year 2024?
Hopefully the rest of world F2B date will continue to advance at least several weeks at a time. Again, we have to kind of monitor this movement and see where it'll go. At this time, I see no reason to believe that rest of world EB2 will be current this fiscal year. Again, I think, and that's based on the information we have at this time. But again, I don't see any reason that rest of world EB2 will become current.
Okay, and then this question is about F2A, final action date. Is there expected to be steady forward movement or no movement until next quarter? And then will F2A final action date reach July 2021 by end of fiscal year 2024? So F2A final action date was current for some time during the whole COVID.
Right.
Period, right?
Yeah, actually the F2A date was current from July of 2019 until, it became oversubscribed. But I think the answer to this question is yes in both instances.
Okay. And then Laura, you want to take this one? Our talent from India has been granted I-140 status. However, the visa is not yet current for India. Can she come here under H-1B to wait for the status to become current? Thank you.
Great. So it sounds like the immigrant petition was approved. The I-140 doesn't actually grant any status, but once approved, that means you're waiting for the priority date to become current. Yes, this individual can come under H-1B. Now, the challenge probably is obtaining the H-1B. So if you're a nonprofit, you might be able to obtain the special sort of exempt status for H-1Bs. Otherwise, this person would be subject to the lottery. So that is often the most difficult part about bringing talent from abroad is obtaining the H-1B through the lottery, which the lottery season is just kicking off in January. That's often where we're consulting with our clients to get the lists to put people on the registration, which will take place in March. So the answer here is yes, coming under H-1B, they can come here to wait, and that with an approved I-140 as an Indian national whose priority date is not yet current, they can continue to extend their H-1B beyond the 6-year limit.
Okay, and then next slide. projections on when I-140 rest of world filers for national interest waiver in spring 2023 can at least file I-485. So that's EB2, right? When will the EB1 China with prior date 12/2022 be current? So Charlie, you got the first one?
Yeah, on rest of world with a 2023 date. But rest of world EB1 is current. So
yeah, I think they're talking about EB2 because
EB2. I think that with a spring of 2023, I'm not sure that it would be late summer at the best.
Yeah, because right now dates for filing is February 2023 for rest.
Yeah, so I think for this, it is more likely to be early next fiscal year, early fiscal 2024 or 2025. But with and in terms of the China employment first preference, again with that date, December 2022, I would think hopefully by September, if not September, early in fiscal 2025, October, in the October to December timeframe.
So that would be October, possibly 2024. Maybe.
Correct.
Okay. Some good movement in F2A final action date, but no movement in the final dates, the filing dates for F2A. Why does that happen? I think you explained that a little bit earlier, right?
Yeah. So they put the application filing date where they think that the final action date will be in September. Yeah. So they're not gonna move it until they feel they need to generate more demand.
And a lot of the F2A is actually processed overseas, right?
Yeah, and that again, the State Department has a much better view, or they're much more comfortable with their view of the family-sponsored demand because they have those petitions at the National Visa Center, so they know those, and they also know how many are already documentarily complete. They've submitted all the required documents, and they know how many are in the pipeline if they need to generate additional demand in order to maximize number use.
Okay. And what is the future of EB2 rest of world category? Will it follow the fate of EB2 India, or is there hope that some action will be taken to prevent that?
I think that they will prevent it. I think it's slow, hopefully steady rest of world employment second preference movement while they kind of, again, monitor the demand and number use versus their monthly target for what they want to use. And again, they're going to try to avoid any type of volatility with the dates. Again, if their target was to use 4,000, if they're using 5,000, they may feel, okay, we'll hold the date for a few months until our monthly average gets into the 4,000 monthly average over the course of 5 months or so. Or if the opposite is, if they're underutilizing numbers, then they may advance the date in order to catch up to their 4,000 target. So again, I think hopefully we'll have steady and consistent movements.
Okay. And then next slide, I think we have a number of questions. So Laura, are there any here that we can answer?
Yeah, there are tons. So here's one. If I've received an interview letter before, but canceled by rescheduling it due to insufficient documents, I've been waiting for the date to be current again. The priority date is current now. I've tried to pick a date, but it's saying no date is available. When can I expect a date to be available?
Well,
any thoughts on that?
Tough. Yeah, because if you were called in for interview, that means that your file should be at the local office already, right? And so you're going to have to be dealing with the local office to try and get your appointment scheduled. But I'm not sure about this, but if it retrogresses and your dates move backwards, I don't know if they send the file back to the service center and then it has to be called again when your visa becomes current. So Charlie, do you know the answer to that? What happens to
that's this is one of those things I always would tell people, avoid rescheduling if at all possible. We used to see this with certain countries where the applicants would be eligible for an appointment early in the fiscal year or throughout the fiscal year, but they would reschedule it or, not hold it so that they could, wait till the summer when the kids were out of school or whatever. And they run into this thing. So you should always, unless it's completely unavoidable, I would strongly suggest attending your interview. And if by any chance you are refused, if you're doing this at an overseas post, if by any chance you're refused during your month of interview, try to get back with the required documents during the course of that month, because they will have a number available for you and they will interview you. But if you have to be interviewed in a subsequent month, you're kind of based on the availability numbers, because the post will have a certain amount of cases can be scheduled for first-time interviews and a much smaller amount of cases, appointment times for those that are rescheduling.
Yeah. And
that could explain
lack
of availability.
Yeah. And that's for this person, their initial appointment, the post may have said, we can interview 1,500 first-time applicants that just became eligible for the month of January. But they may also say, well, we can only accommodate 200 applicants who are attempting to reschedule their case from an earlier month. So, it's a issue of, staffing to handle the case. And they often may feel, well, if you didn't hold your original interview time, we're going to take the person that is likely to come in when they're initially scheduled.
Yeah, and it's hard to find the file, to be honest with you. You can use Ask Emma, right, Laura, and try and see where your file is. But sometimes people have to go through congressional assistance, but it's tough when it retrogresses and you don't know where the file is, and you have to try and figure out how to get it, in front of the Immigration Service, because now your date's current. So that's a tough situation. Laura, other question?
This is we've touched on this, but maybe just an overall summary. With such a bad backlog in F2A, why are all family-based visas not being utilized?
I had kind of the same question when I saw that this year's employment limit is 161,000. That means that there were 21,000 unused family numbers last year. And many of the family final action dates at the August and September were held, and possibly even for July. If you are going to be under the limit, I would not have been holding the dates. You would, if you know you're going to be underutilizing numbers, you advance dates in order to cast your net wider and have available applicants. Staffing may not have allowed that, so there's issues involved. But again, I think the State Department, for fiscal 2024, I would expect that the family annual limits will be very close to the limit. The number use will be close to the limit.
Okay, here's we've kind of answered something similar, but it seems like folks are really looking to understand the difference between final action and dates for filing. So this kind of goes to that. The final action dates are trending forward, while the dates for visa filing are moving backwards for employment-based visas. What should we take away from this? And I would think the visa filing date, Table B, would move forward the same way the final action date would.
No. So say that the first preference annual limit is, say, 50,000 numbers. So the State Department, in consultation with the Immigration Service, would have said they know they have 35,000 applicants that they know are in the pipeline now. That means 15,000 under the limit that they still need to use. It's fine. So they would set an application filing date far enough in advance that would allow at least 15,000 applicants to file so that they could fully utilize the 50,000 annual limit by the end of the year. During the course of the year, the Immigration Service, since they're using the vast majority of the employment numbers, they will look at how many employment numbers have been used versus on the 50,000 limit. They will see how many people they have in the pipeline, and they will see, okay, the amount of numbers that have already been used and the amount of people we have in the pipeline who have already filed exceeds the 50,000. Therefore, we do not need any more people filing based on the application filing dates, and they would shut those off and only allow people to use the Chart A final action dates to file.
Because they're assuming that it will take the Immigration Service, about 10 months to hit that date and approve those cases?
Yeah. And so the application filing date is where they believe the final action date will be in September. And when they advance it during the course of the year, then they believe that's where the final action date will be in 8 to 12 months in the future.
Yeah. Yeah. So Laura, we're getting questions about whether people should downgrade, right? Changing lanes. What's your response to that?
Yeah, this is a tough one. I took a call this week with a client on this one. I think this is challenging, and I think we got to walk through what your preferences are. There's absolutely a huge benefit to filing your adjustment of status and getting it on file. So there's a question here that's kind of about, I've got an I-140 approved in EB2 and EB3. Should you go with the EB3 to file the adjustment? And I think the answer is there's such substantial benefits to filing your adjustment of status. So I guess I'm assuming the question is, you have not yet filed your adjustment of status. Getting it on file, you get huge benefits of portability after 6 months, an EAD, and an advanced parole card. If you're in the situation where you filed under EB2, but you're seeing the dates advance under EB3, so you want to downgrade, like Charina is saying, I would advise caution on this one. So this is someone who already has a adjustment of status case pending. In the event you're considering downgrading, I would only do it if your date is current for final action. And even then, sort of talk with your attorney, talk with WR, schedule a consult to understand what the implications of that means, because what we saw in 2020 is cases that went to downgrade, we then saw it reverse and that EB2 became more favorable. So just be mindful that if you do this, you could be in a situation where you're upgrading again. So if your company is supporting the filing fees, if you're in a position to support all those filing and legal fees, you can do that. It does complicate the case. And from our experience, and again, USCIS does not list any data on this, those cases were taking longer. So it complicates your case, and that you think about it from the officer's standpoint, that's a harder thing to do. They have to spend more time with your file. So just something to think about. I don't know, Charina, if you have any concluding thoughts here on that.
Sometimes, the question is, can you just stay in your lane, right? It's very tempting to move into the faster lane, and then the faster lane becomes slower, and then try and move back to the other lane you were in. And I think it's just a hard thing to advise clients on. And I think, in that situation, if you can't wait, you can't wait, and you want to try, and then you want to try. But we go through it. So I recommend you just schedule a consultation with us, and we'll walk you through it. We're actually at time. So wanted to thank Laura and Charlie for our anniversary, 1-year anniversary of chatting with Charlie. We'll be back in January again. And any parting words, Laura or Charlie, as we end off the year?
The one thing I would think, and Laura mentioned all the FAQs that the USCIS has released. I think that is in part because of events like our webinar, where we've suggested that it would be nice if USCIS would start posting more information, and other people that do webinars. I think this is a very positive sign that USCIS is listening and is starting to be more proactive in their attempts to get information out there. And so I think it is very good if during the course of our events, if we make suggestions in terms of the release of information.
Laura?
I learned so much from you, Charlie, every month. I hope you all do too on the line. Keep sending in your questions, and that if you register early, you can send in your questions to be addressed first. So go ahead and do that.
Yeah. Thank you, everyone, and happy holiday.